questions I can ask you as well. So welcome, everybody. So excited to have you in class today. My name is Curry Sautner, and I'm the Chief Learning Officer at the National Constitution Center. Today's class is open to learners of all ages. So we have high schoolers and middle schoolers and adult learners with us today. And the topic of today's class is Article 1 of the United States Constitution. It's all about Congress, the legislative branch. And on Friday sessions, we are so lucky and happy to have great scholars join us. And today's great scholar that joins us is Professor Lawson, who is at Boston University. He's a professor of law. He has taught with us in our Summer Teacher Institute for teachers around the country and has always brought so much information to the table, as well as ideas and enlightening to get us thinking and keep us moving even further. We will also be joined today by the president of the National Constitution Center, Jeff Rosen. Perfect timing, Jeff, just as I was introducing you. So we have great conversations on the Constitution today, great conversations on how Congress works and all that's going on in Congress today. So without further ado, Jeff, let me turn it over to you.
Thank you so much, Curry. Great to see you. Happy Friday. And Professor Lawson, so great to see you. Welcome to the National Constitution Center's Friday class.
No, honor to be here. Thanks so much for having me.
It's an honor to have you and to learn from you. You've written so many important things about Congress and the founders' original vision of it and how it's evolved. So I'd love just to begin at the beginning and tell us, why did the founders create the Congress? Why were they convinced that it would be the most powerful branch? Did they fear that it might be too powerful? And how did they choose the powers that they allotted to it?
Let's see, we have how many semesters?
Exactly.
No, here's the short answer. The founders would pretty much all today be classics majors. They were obsessed with learning about the classics, about Greece and Rome. So they had 2,000 years of models to look at. And the Roman legislature, which has really two bodies, was around for a very long time. And then they had the English Parliament, which has both a House of Lords and a House of Commons. So the idea of a multi-cameral two-house legislative body was very familiar. All their study of history suggested that that was the right way to go. What multi-bodies do is bring different constituencies and different ideas to bear so that nothing can happen without some measure of consensus. And that was one of the driving forces for the structure of the legislature. As to why they both wanted and feared the legislature to be the strongest, they had several hundred years of English history to deal with, where there were bitter disputes, sometimes outright civil wars involving the power of the legislature versus the power of the king. And they came down on the side of the legislature. In 1776, when all the new nations, we can't call them states because there wasn't a United States until 1788. So for 12 years, you have 13 independent nations. They were all adopting their own constitutions, frantically revising them and then redoing them, all in the midst of a revolutionary war. Their original move was to a very, very powerful legislature because they were fighting the king. They were opposed. Nobody wants a king. So they had very weak governors, very strong legislatures. After about a decade of experience with that, by the time you get to 1787, they're not so hot on the legislatures. They didn't quite do what everybody wanted them to do. So you had a very rapid shift in a very short span of time on how they wanted to balance off the powers of the various institutions. And here's the real fun one. The third department of the federal government, the courts, until about the mid-1700s, mid-18th century, there was no such thing as a judicial branch. They were all executive agents. So now they have to throw in this third institution that they have no real history with. So this is a very, very delicate balancing act. But their vision of what they wanted the legislature to do and what they were worried about legislatures doing, that is driven very strongly by history that some of them had lived and all of them had learned about.
Wow, that's such an exciting introduction to our topic. And you've told us so memorably that the founders studied the failed democracies of Greece and Rome. They learned from their experience in the classics. They had implemented it during the Articles of Confederation period. They created really strong legislatures, you told us, in the early state constitutions, including that famous Pennsylvania legislature with just one house. And based on that experience, they were determined to separate powers using the Roman and British constitutions as a model. I have to ask you for just one more beat about the classical and British models, because I'm so interested in them. I can learn so much from you. What we've talked in this class about how Madison said in Federalist 55, in all large assemblies of any character composed, passion never fails to wrest the scepter from reason. Even if every Athenian had been Socrates, Athens would still have been a mob. Was there something about how did the Athenian assembly work? Was it just one body with a lot of people and they were scared of that and they thought the Roman separation was better? Tell us a little more about the classical models.
Yeah, that's. I mean, I am not a classicist myself. My son is a classics major.
Oh wow!
I'm not a classicist. So I don't want to speak with any authority on those sorts of questions. But yeah, I think you've actually nailed it. They were very much afraid of what today we would call democracy. They would think of that as mob rule. So what they were trying to do was to create institutions that would divide up the powers, they wanted to make it hard for governments to do stuff. And if you're looking at the history of the last 200 plus years, how the role of Congress and the understanding of its powers and functions has developed, largely it's the story of how that idea has changed over time. There have been periods of US history when the notion that you want to make it hard for government to do things was very much out of fashion. And these things cycle. They cycle in, they cycle out, they push this way, and the powers of Congress get changed because the 18th century model doesn't fit, say, late 19th and early 20th century conceptions, mid 20th century conceptions of what you want government to do. So yeah, the focusing just on 1787 and 1788 for a minute, yeah, they wanted a government that could do more than the Articles of Confederation could do, but they were very, very leery about entrusting fallible people with lots of power. And they were almost paranoid about that sort of thing. There are provisions in the Constitution that you look at and you sort of scratch your head and say, why would they do that? Prohibition on members of Congress being appointed to executive or judicial positions whose salary has been increased during their time in office. You're going to write that into a short constitution? Well, yeah, they were worried that we're going to have a bunch of corrupt venal gas bags, right? Going to loot the public till, and then as soon as they got voted out for being gas bags, well, they'd have themselves appointed to cushy government jobs. There's actually a constitutional provision to prevent that. It's a constitutional provision that prevents members of Congress from serving in the cabinet, right? So you can't have a parliamentary government like they did in England. These are very small provisions that nobody thinks about, but they're actually incredibly important parts of the structure of how Congress was understood. It was understood to be the locus of the most important power, primarily the power of money, the power of appropriations, the debates you're seeing today about the spending bill. That's the heart and soul of what in the 18th century people would have thought of as the legislative power. It's the power of the purse. And there's even an obscure provision in the Constitution, very important in English legal history, that says nobody can spend a cent of federal governmental money without an appropriation from Congress. So every once in a while, when you get these showdowns over the budget and people talk about a government shutdown, well, There are offices that literally have to shut down. You would be violating a federal criminal statute if you turned on the lights and created an obligation to the power company when you didn't have a congressional appropriation giving you the money to do it. So yeah, worries about congressional power were very much there, but they also were very unhappy with the way things had developed in the previous years under the Articles of Confederation. So this is a balancing act that's still going on today. It's a different balance than you would have seen in the 18th century. The same issues, exactly the same issues.
It's so meaningful to focus on the text, as your work has emphasized we should do. And in Article 1, Section 8, we have a number of powers herein granted to Congress. You've divided them in one of your pieces into 18 separate powers, and they're specific and enumerated, but then they end with a catch-all phrase, which you've written a very important article about, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. This, as you've noted, was called the sweeping clause. And I remember back when I was many years ago, your article on the sweeping clause and what its extent and also limits were. So what was the sweeping clause and how did the framers understand it?
Right. This is going to get a little bit technical. Suppose that you are just a business person and you want to send somebody over to France to work out whether that you can market your goods in France. You're going to send them over with some kind of instrument authorizing them to do stuff. They're not authorized to sell your business out from under you, but they're authorized to make deals and arrange for sales. There's all sorts of details about how that might work. Are they only allowed to arrange sales for cash, or can they arrange sales for credit? You tell them that they're supposed to go to France to sell your goods, but the weather is bad, so they have to divert to Portugal. Can they make a decision on the fly to sell your goods in Portugal instead, if that's the alternative is to throw them overboard and let them run? Now, you can write a very elaborate document, like a telephone book, dealing with all of these contingencies, but you're going to have to pay the lawyers to do that. And there's always going to be stuff you're not going to think about. So you're going to have to think about, all right, there's certain main things I'm authorizing this person to go do, but there are also things that might be, the technical word is incidents, things that kind of go along with what they're doing. And over the course of time, as you acquire large bodies of contracts and the courts deal with them a lot, there are certain traditions and customs that arise. Some things you just don't have to say anymore. They're just taken for granted as the sorts of tasks that go along with what you're doing. What does any of this have to do with the Constitution? Well, the Constitution is kind of like that document that sends the agent to France. You've got this entity called We the People of the United States that's ordaining and establishing this Constitution. What the Constitution is really doing is creating a bunch of agents to go out and manage some portion of the business of We the People, just like a business person could have an agent going over to France to manage some portion of their affairs, or you take 6 months off, you need someone to manage your farm, so you get someone to manage your farm. It's very much the same kind of idea with exactly the same issues. There are certain principal tasks that you're going to want that agent to perform. Those are primarily the 18 subsections of Article 1, Section 8 that lists the 18 principal powers of Congress. There are a few others as well elsewhere in the Constitution. What about things that are part and parcel of that? Incidents. Well, documents in the 18th century of this sort routinely contained provisions just like the necessary and proper clause. Wasn't something that came out of thin air. The people who actually wrote the words of the Constitution, 4 lawyers and a businessman. And what were they doing in their spare time when they weren't writing a Constitution? They were writing these contracts for the business people, sending their agents overseas. This is very familiar territory. So what that clause really does is acknowledge and to some extent cabin these incidental powers of Congress. If that clause did not exist, if it was repealed tomorrow, would there still be things that were just incidents, things that went along with the power? Congress has these lists of powers. The power to create federal offices is not listed. Now, the only executive offices created by the Constitution are the president and vice president. Constitution says nothing about an attorney general or a secretary of HHS or deputy undersecretary of state. Those are all created by statutes, by laws enacted by Congress. If you didn't have this clause at the end of Article 1, Section 8, would that mean Congress would have no power to create those offices? Well, no, I think what people would say is that creating an office, that's an incident. Congress has this power, say, to tax and to set up post offices and post roads, and just part and parcel of what that means is there's certain things you get to do along with it. There are certain things you might not get to do. And in the 18th century, there was a very elaborate body of law, not about governments, but about these private agents being sent to manage farms and sell stuff, that distinguished what counts as a principal power that you either have to list in the document or they don't have it, or incidental powers, things that kind of go along with the powers that you give. So what that clause really was just a description of the kinds of things that go along with the principal powers that you're giving to Congress. And figuring out the exact details of that, you have to take a very, very close look at 18th century law about private business agents. That's what legal scholars do. They do technical niggling stuff, like looking at what 18th century contracts for business agents had to say. But I think that tells you a great deal about what the understanding was about what Congress could do. Now, that's not how the courts have understood this for the last 200 years. Chief Justice John Marshall understood it. If you ever read the great case of McCulloch versus Maryland, there's 7 pages that gets deleted from all the constitutional law casebooks that actually talks all about this private agency stuff. Principal powers, incidental powers, great substantive and independent powers, things that you have to list in order for Congress to have.
Absolutely fascinating. And our friends who are listening are right with you, and both Warren Wolf and Colin Thibault say, please discuss the abdication of responsibility of Congress to administrative agencies. What do you think of the non-delegation doctrine? For friends who are not as up on these technicalities as Warren and Colin, these are limitations on Congress's power that courts have recognized at some time in the past and at other times have repudiated. And Professor Lawson, you've written a lot about this, but of course, helping our friends, many of whom are in high school, understand the contours of this important debate. What can the question of what's an incidental power and what isn't tell us about whether all of these administrative agencies that often were created during the New Deal are within Congress's power to create or not?
3 separate questions when you're thinking about Congress. One is questions about what exactly is it? What is its structure? How does it operate? Second set of questions, what can it actually do? What are its powers? That's the subject we were just talking about. Third, how does it exercise those powers? That's this separate question. Question of whether Congress can create an executive agency. That's one question. Once Congress creates that executive agency, what do the laws creating that agency have to look like? What do they have to say? How many of the decisions have to be made by the legislature versus the agency, or indirectly the courts reviewing the agency? That's a third category of questions. And I think the answer also comes from the same analogy to sending your agent overseas. All right, you pick somebody to go sell your goods in France. That somebody gets to France and says, hey, France is kind of a nice place. I think I'll go to the Riviera and take a vacation, and I'll just have somebody else do that job for me. To what extent can the person who you've just entrusted with authority punt that authority off to somebody else? This is not a new idea. It's not something distinctive to government or to Congress or to the US Constitution. The business people and people picking folks to manage their farms, they had to deal with exactly those sorts of questions. Same kinds of answers. You can authorize the agent to subdelegate their authority to anybody you want. If you don't specifically authorize it, are there certain circumstances where it's just kind of understood that they can do that? You hire somebody to go sell your goods. It turns out that the only way to sell them is an auction, and you can't run an auction without getting an auctioneer's license. Does the person have to get an auctioneer's license? Or if they have to be a lawyer, do they have to get a law degree and then they can go sell your stuff? Or can they hire an auctioneer or a lawyer to do the job? That's just this part. Huge volume of 18th century law on that as well. So when you translate that into the structure of a government, you've got exactly the same kinds of questions. Congress is given all of these powers. Does it exercise those powers by picking somebody else to do the job for them? We call that the delegation doctrine. It's really the sub-delegation doctrine, because Congress has already been delegated power from we the people. The question is, can it then pass off that delegated power to somebody else? This has been an issue for more than 2 centuries. It had kind of vanished from American law for about 75 years, from 1935 to 2019. The number of Supreme Court opinions that took that idea seriously was exactly 0. And indeed, there were any number of Supreme Court opinions that said, more or less, stop worrying about that. We're long past that. Maybe that was a problem in the 18th century. It's not a problem today. In 2019, the Supreme Court decided a case that put that back on the map. 3 justices said, let's bring it back. A 4th justice said, I'd bring it back too if there were 5 votes, but there were only 4. And there have been 2 justices added to the court since that time who did not participate in that decision. So this is now a very live issue in a way that it wasn't for most of the last century or so. And again, I think the answer to these questions, as I think the answer to a lot of questions lies in thinking, okay, who's writing this stuff? Who's deciding? What were the institutions they were familiar with? And they were very familiar with the idea of authorizing somebody else to act on your behalf. And there were lots of legal rules about how to, they're not going to write them all in because everybody kind of knows that stuff. And throw one more thing in history. People who are not lawyers in the 18th century, who are not writing these instruments of agency, authorizing people, they're living them. Think about guardians for minor children, same kind of instrument. People died a lot in those days. You had a lot of guardians. Executors of wills, same thing. You're giving them authority to do stuff. All these questions come up in that context. Sending people to manage your business across state. Can't pick up the telephone and call. You got to send somebody out there to do it. Got to send somebody to collect a debt. Can't just send a computer email message saying you owe me this, but actually physically go and collect the debt. So people were living this whole idea of authorizing others to act on your behalf. So these legal rules were part of everybody's life. We've lost a lot of that over the course of more than 2 centuries. Law schools do not teach anymore what we call the law of agency, the law of authorizing other people to act on your behalf. 100 years ago, that would have been a required law school course for everybody in the country who was a lawyer. It's not taught anymore. So anyway, that's part of, I think, why the conversations today would look very strange to people in the 18th century. And let me throw one more thing in, just a gas bag here. We talk about the 18th century. Some of the most important powers of Congress do not come from the Constitution of the 18th century. They come from the Constitution of the 19th century. There were 3 very important amendments after the Civil War, the 13th, 14th, and 15th Amendments, and they all contain grants of power to Congress. And those are some of the most important grants of power to Congress there are. And they were enacted at a very different time with very different understandings about these basic things and about the basic role of government. So assumptions that would make sense in 1788 do not necessarily make sense for a provision enacted in 1868. So just keep that in mind. Different provisions adopted at different points in time with very different assumptions about what the issues and what the problems are.
So interesting. Thank you so much for that. Thank you, friends, for learning from Professor Lawson. The 2019 opinion that he mentioned is called the Gundy case. We'll put it in the chat if we can. The majority opinion was written by Justice Kagan, the dissenting opinion by Justice Gorsuch. And as Professor Lawson suggested, there was a big debate between the justices about how much delegation was consistent with the Constitution. Justice Kagan said in her majority opinion, if the delegation here is unconstitutional, then most of government is unconstitutional. Dependent on Congress is on the need to give discretion to executive officials to implement its program. Justice Gorsuch countered that his vision of limitations on power would not mean that most of the administrative state, as he called it, is unconstitutional. And as Professor Lawson said, the court is divided on this question. I'll ask one more question, and I know Curry has a lot of questions from our friends in the chat. If Justice Gorsuch's vision were to get 5 justices and be adopted by the court, and there were to be a resurrection of the non-delegation doctrine, as it's called, what kind of government agencies or activities would be unconstitutional today?
We don't know, because we don't know what version of Justice Gorsuch's idea 5 justices would sign on to. There's actually a famous line in Justice Gorsuch's dissent where he says the real key question is, quote, what's the test? That is, it's very easy, I think, to establish that there is something called a doctrine against subdelegation, some limits. Could Congress just create what I call the Goodness and Niceness Commission, give it all power to promote goodness and niceness, and then all the members of Congress go to the Bahamas on vacation? Okay, no. But between that and anything else, where is the line? And Justice Gorsuch spent a lot of time in his dissenting opinion trying to lay out exactly how to draw that line. It's none too specific. He very conspicuously avoided mentioning any agency or statute that most people would care about. All the examples he gave were kind of oddball, insignificant little things, not talking about the Clean Air Act administered by the Environmental Protection Agency. He's not talking about the Occupational Safety and Health Act, right, which has been in the news recently with the Biden administration's vaccine or testing mandate done under this very broad statute, the Occupational Safety and Health Act from 1970. Doesn't mention any of those. So exactly how deeply a delegation doctrine would cut depends very much on how you formulate it. And there's actually a book coming out to which I contributed a chapter literally any day now, where you just gather up a bunch of legal scholars and they each contributed their own version of what a test might look like. So you've got 15 competing ideas out there of what a test would look like. But of course, none of those 15 ideas actually matter, because what only matters is what 5 justices of the Supreme Court come up with. And we do not have a clue what that might look like. It could be very, very narrowly cabined, could potentially be very broad, although given the history of the Supreme Court, that's probably not likely. But that's anyone who knows. If I actually knew the answer to that question, I would not be here. I would be auctioning off my knowledge on eBay to the highest bidder and making a fortune. Because whoever can actually pick that out in advance is going to be very, very much in demand. This would be a very good skill to have, to be able to prognosticate like that. I can't. That's why I'm a law professor. So it's a fantastic question. It is the question everybody's asking, but kind of like it's not a ball or strike until the umpire calls it. We won't actually know until we see the next case. And that probably won't be for a few years now.
Wonderful. Well, when you figure it out, maybe we can get a cryptocurrency investors together to bid on it, as they did on the Constitution yesterday. And they didn't quite win that bid, but I'm sure they'll want to bid on your knowledge, which is vast. And you've shed so much of it in this great conversation. Curry, our friends are full of questions in the chat. Over to you.
Let's do it.
Awesome. Thank you so much. And we just appreciate kind of laying out all these pieces for us so much, because the chat is going crazy and it's been a conversation we've had all week. So lots of questions throughout the week. So Edward wanted to understand gerrymandering. Was this an issue that the founding generation were worried about? Give us the background of gerrymandering, where the name comes from, all those pieces.
The correct name is actually gerrymandering, because it's named after Eldridge Gerry, who was a Massachusetts legislator, who is notorious for drawing a district to elect himself that looked kind of odd. So this is actually a more than 200-year-old term. So this is not some new or novel idea. There's nothing, by the way, in the Constitution that requires that members of Congress be elected by district. I mean, if you think about how senators are elected after the 17th Amendment, they're elected by a statewide vote. It's not county by county or district by district, the whole vote of the state. There's nothing in the Constitution that prevents members of Congress from being elected the same way. That's a function of statutes. It's been done by district since, I have to double check the date on this. I think it was like around 1840 or so that statute got onto the books prescribing election by district. We've sort of done it that way ever since. But any time that you're going to have election by district, obviously you have to come up with a way of drawing what those districts look like. And if you draw it at one particular moment in time, by the time you get around to an election, it's actually going to look different because people move in and move out. For most of the nation's history, it was left to state legislatures, subject to if Congress wanted to override it. Congress could do so. It's a constitutional provision that allows that. It was up to state legislatures essentially to carve up the state however they wanted to. And sometimes they would carve it up by population, and sometimes they'd carve it up by geography. Sometimes they'd carve it up by the farming district over here, and you got the manufacturing district here and the mining district here. In the 1960s, Supreme Court decided some of the most important cases in the history of the United States that they're sometimes misrepresented as saying that they prescribe a constitutional rule of one man, one vote. And that's not true. If that was true, then you would have to have all elections at large. You couldn't have elections by district. And nobody's ever interpreted that way. What they do say is that you have to make some significant effort in making these districts to have a measure of population equality. Doesn't have to be exactly equal. You could have one man, 1.03 votes. You can't have one man, 1.08 votes, and exactly where in there. So that's one constraint now. You've got to restrain the population. But of course, you can carve up a state more or less equal by population in a way that looks like, weird lizards and so forth. The question is whether there is an additional requirement that there not only be population equality, but that the district lines look, there's a technical word for it in political science called compactness, right? That's just a way of making sure that the lines don't go across this neighborhood and cut this neighborhood out. As of this moment in time, we do not have a constitutional rule requiring that kind of compactness. We just have the general, you got to try to make the population kind of sort of equal, and that's as far as it goes. And indeed, the last time the Supreme Court was asked to weigh in on this, it decided it couldn't weigh in on it. It was simply not within the purview of the courts to decide, for example, whether legislators who draw up these districts were doing so in order to secure advantages for their political party and to screw the other guys. Well, of course, they do that all the time, right? Question is whether there was a constitutional rule against that. They didn't say there wasn't. They said we just can't say. So this notion of how you're going to draw these districts, that's been around for more than 200 years. It's generally been left to the realm of politics. There are some states that have tried to create so-called independent commissions. Whether they're really independent of who and what is a different question, but commissions that would come up with these electoral maps rather than leave it to the legislators themselves to whether leave it to the foxes to design the guard mechanisms for the hen houses, so to speak. But yeah, that's been around forever. That's not new.
Again, things we've been talking about with Congress, the entire scope of American history. In Pennsylvania, they have a commission that's looking into that, but they also—
a lot of states have these commissions.
Yeah, there was a statewide project called Draw the Lines that asked the students to see if they could come up with different ways or more like inventive ways to draw the lines. So kind of interesting. So our other question around this is around looking at the filibuster. That was like the big question of the week. And it was less about like the outcome of the filibuster, but what's the history of the filibuster? Because you connected so much in your brain with Congress. So Congress, you hear the filibuster, what's the storyline around that?
All right, the Constitution sets up the House and the Senate. It prescribes how a law gets enacted, right? Doesn't say much beyond that about how the House and Senate run their business. It just has provisions saying they can adopt rules for their own proceedings. And that's it. There's actually nothing in the Constitution that specifically says that the House and Senate are supposed to act by majority vote. You can infer it from certain other provisions that prescribe supermajority rules in certain circumstances, and that pretty good indication that majority rule is the baseline, but that would just be for things like how you pass a bill. Filibuster is not about how you pass a bill. It's about when you get around to voting on passing a bill. It's a rule about who gets to talk and how long they get to talk, and when you can shut people up and say, okay, let's stop talking and start voting. And the House has its own rules on that. House of Representatives have quite strict limits on how long people can talk. So that's why they vote a whole lot more often than the Senate does. All right, so why would the Senate want to put rules in or limiting the amount of time that people want to talk? Well, I am no expert on the filibuster. I have a co-author, frequent co-author, who's an expert on the filibuster. And I wish he was here to talk about this. But my understanding is that it had its rather unsavory origins in debates over slavery. And it was lots of things going on in the 1830s and 1840s that people wouldn't want to hear debates about ending slavery or limiting. Just Southern senators didn't want to hear it. So the prevents the effect of the filibuster is to make it possible for people to talk until the advocate of legislation just gives up and goes home. Like a lot of other institutions, the filibuster has acquired uses going way beyond its original origins. I mean, people today, I don't think would view the filibuster in light of where it came from. It has its own function, and whether you think that's a good function or a bad function depends on how easy or hard you think it should be for the government to do anything. I don't know if this term came up in over the last week. Political scientists, I'm not a political scientist, political scientists talk about things called veto points. Those are just the spots in the process of getting something done that can stop it. And obviously one veto point for a law is the president vetoing it, right? Another one before that happens is Congress fails to pass it, right? In two houses of Congress representing different constituencies, they don't both agree on the same thing, nothing happens. There are going to be veto points before that, because before either house of Congress can vote on something, if you can stop it, even from coming up to a vote, that's a veto point. The filibuster would be one. The committee system, which again is something just set up internally by the House and Senate, nothing in the Constitution about congressional committees, right? Don't have to be any, they've just set that up. And because of the way they've set that up, you can stop something at a very early stage in the process if the committee just doesn't report it out. So these are all ways of slowing things down and making it hard to get stuff done. Now, if the thing that's being slowed down is something you care about really, really deeply and want to have happen, you're going to think that's a terrible and awful thing. If the thing that's being slowed down you think is a disastrous piece of garbage, you're going to be thrilled More veto points, right? So these are tools, and your general assessment, probably going to rest on a general assessment of whether you're worried about any level of government doing too much or too little. You think it's going to do too much? Filibuster is not such a bad thing. If you think it's going to do too little, the filibuster is just one among a number of obstacles to action that you're probably going to be unhappy about. The one thing I will say about the filibuster here, I think almost everybody, regardless of their views on the filibuster, agrees with. It's a Senate rule, just a rule of the Senate. It says you need 60 votes to cut off debate on a measure. There's another provision that says, and this rule can't be amended unless 2/3 of the senators vote to amend it. I think almost everybody agrees that provision is unconstitutional. That is, if a majority of the members of the Senate at any given moment want to change their rule, they can change that rule. And the rule can't make itself unamendable. One Senate at one moment in time can't prevent the next Senate from amending the Senate's own rules. I think you would get near universal agreement on that part at least. So you get 51 senators to vote to change the filibuster rule, they change the filibuster rule, and that's it. But as long as it's on the books, that's how they want to run their debates. They could have a rule that says you can, anytime you're debating, you got to wear a Yankees cap. I mean, they could do that if they want to.
That is a really unbelievably helpful. And as we wrap up, and I know we've kept you a little longer, and I apologize, but
I would do this all day long. I would do this all afternoon. Okay.
And I think all of our students would keep asking questions. I know like bells are ringing in schools and places, and but I love that idea that you're bringing us back to look at the Constitution, and that's been like the theme of this class today. Look to see where Congress gets its power, look to see where Congress gets a limitation, but look at the process and how it's set up in the Constitution, but also by the way Congress has set it up, by the way Senate has set it up in the first place. And is that the way it's supposed to work? Or is that a backlog in it? And I think all these questions are so important as we engage in the Constitution and really understand that we are, as you said earlier, constitutional agents and how we have to play a part in this role. So thank you so much. That was really helpful to break it down to understand process and the pros and cons of the process.
I would say we're the principals and they're the agents.
Now I even like that even better.
Yeah.
Awesome. Thank you so much. That was a fantastic class. Jeff, thanks so much for all the great questions, and students, all the great chat in the chat. Thank you so much for sharing links and everything. Our students are so good at sharing links that I get to really take it easy over here.
Carrie, before we go, if you have a printout or a copy of the chat questions, if you send that to me, I'll try to type up a set of answers to them and send them to you, and you can do with them whatever you want.
Thank you so much. This is why I will send it out to everybody, because I'm sure everybody will love to see your answers too. And this is why we're so grateful to all of our Friday guest scholars, because you all are the best teachers and care about our students. And we thank you so much. Jeff, I'll turn it over to you for a wrap up.
I couldn't have said it better. Thank you so much, Professor Lawson. That's so generous of you. And that spirit of answering questions and learning together is invaluable. We're so lucky to have your insights. Thank you for that. Thanks for all you do to inspire people to learn about the Constitution, and have a great weekend, everybody.
Thank you for the NCC and everything that it does.
Wonderful. Thank you so much.
Bye.
Bye, everybody.